All right. Let's go ahead and be on the record in case number 2020-CR631, captioned State of Kansas versus Eddie Joe Johnson. Would the parties announce their appearances, please?
May it please the court, the state appears by Assistant District Attorney Claire Thibodeau.
May it please the court, defendant appears by David Matthews and through video.
All right, we are here set down for a plea. I'm not sure where my court reporter is, so I just put record on this. And if we need to make a record at some time in the future or make a transcript, the court reporters can download it from here and make a transcript off of that. As I said, we are here for a plea. I've received the plea petition. Mr. Johnson, I'm going to have to ask you a lot of questions. Dave, I think that's the hallway noise. Can you mute yourself?
Yes, Judge, I'm sorry.
Okay, that's quite all right. There we go. That better? Mr. Johnson, you hear me okay?
Yes.
Okay. So I'm going to ask you a bunch of questions, all right? If anytime I ask you something and you don't understand what I'm asking you, tell me that and we'll talk about it until we're both on the same page, okay?
Okay.
If at any time you want to talk to Mr. Matthews in private before you answer a question, just like I sent you and your mom out, I can send you and he out so you can have a private conversation. You just let me know if you need to do that, okay?
Okay.
All right. Now to get started, I have to swear you in. So would you raise your right hand, please? You swear the testimony you're about to give be the truth, the whole truth, so help you God.
Yes.
All right. Thank you. Go ahead and put your hand down. Mr. Johnson, how far did you go in school?
I say 11th grade, but I almost finished the 12th.
All right. You reading right okay?
Yes.
All right. I know you're in custody, but as you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what we're doing today?
No, sir.
All right. You feel like your mind's clear?
Yes.
All right. Do you know what you're charged with?
Yes.
All right. Now, you know you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on this case. Do you understand that?
Yes.
At that trial, the state would have to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Matthews would be able to assist you throughout that trial. He could cross-examine all the state's witnesses, challenge their evidence. He could call any witnesses you wanted called. And if they didn't want to come to court, he could use the subpoena power of the court to make them come. Do you understand all that?
Yes.
At that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, they couldn't get up and say, well, Mr. Johnson must be guilty because he didn't tell you his side. You understand that?
Yes.
If we went through that entire trial and at the end of that trial, you were found guilty, you would have a right to appeal that conviction to the appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes.
All right. Now, if we go forward with this plea, you're going to be giving up all of those rights. There's not going to be a trial in this case of any kind. Do you understand that?
Yes, sir.
All right. I want to share with you now the plea petition in this case. And I want to ask you first, can you see that document?
Yes.
All right. You recognize it?
Yes, sir.
All right. Is this the plea petition that Mr. Matthews either sent to you or went over with you?
Yes, sir.
Okay. Now, did you have a chance to read it all? Did Mr. Matthews answer any questions that you might have about it?
Yes, he did.
All right. And you feel like you understand everything in it?
Yes, sir.
Okay. I see here that there's part of it that sets out what the plea agreement is. It says that you're going to be pleading to count 1, which is possession of marijuana with intent to distribute, which is a severity level 3 drug felony, that the state's going to dismiss the rest of the counts. And the parties are going to recommend to me that I give you a downward dispositional departure to grant you probation and that you stay on probation in your old case. Is that your understanding of the whole plea agreement?
Yes, sir.
Has anybody else promised you anything other than that to get you to plead today?
No, sir.
Has anybody placed any force or threats against you to make you plead today?
No, sir.
All right. Now it talks about a recommendation for a particular sentence, a probation sentence. When we're done with this, I'm going to order a pre-sentence investigation be conducted, and it's going to come back with a report on your criminal history and the charges and what your sentence is presumed to be. You understand, when we get to that sentencing, I'm going to be listening to everybody's recommendations, but I'm not bound by any of them, and I can give you any sentence that the law allows me to give you. You understand that?
Yes, sir.
Okay. Mr. Matthews, do you have an idea what your client's criminal history might be?
Your Honor, when we had looked at it, we thought that he would fall in the G box.
Okay. So you've seen those sentencing guidelines that Mr. Matthews and I are referencing, Mr. Johnson?
Yes, sir.
Okay. And Mr. Matthews probably gone over with you how you take this crime and you put it in with where they think your criminal history is going to be, and you get a sentence that you can expect to get, correct?
Yes.
Okay. Now, that's the lawyers using the best information they have. Like I said, I'm going to order a pre-sentence investigation. It's going to take a deep look into criminal history. And you understand that if your criminal history is worse than your lawyer knows about, you might get a higher sentence than you and he had talked about. Do you understand that?
Yes, sir.
Okay. So what that makes me do today is I have to assume, for purposes of today's hearing, that you have the very worst criminal history possible, so I can advise you what the maximum that anybody could get for this crime is. You understand that?
Please say that again.
Just for today's purposes, so that I can tell you what the maximum that anybody could get, I'm going to assume there's a possibility that you could have the worst criminal history possible, so I can advise you what the maximum sentence is for this charge is. Does that make sense?
Yes.
Okay. So the worst that anybody could get for this crime would be 83 months imprisonment and a fine of $300,000. That would have a post-release supervision duration of 36 months. Do you understand that's the maximum sentence in this case?
Yes, sir.
Okay. All right. Do you have any questions for either me or Mr. Matthews about anything that we've talked about today?
I have a question. I won't be able to waive a pre-sentence investigation.
No, we can't waive a pre-sentence investigation. In felony cases, I'm required to have one.
Okay.
And I assume that's because you want to get this done with and get on the probation, right?
Yes, sir.
All right. Well, here's what I tell you what, we're going to take up after we finish this plea. It's not part of the plea agreement, understand that. But if the parties are going to be recommending probation, I'm going to be asking why they think you need to stay in jail awaiting sentencing, okay? So we will cross that bridge when we get to it, that's for sure. But as far as this plea goes, do you have any questions about anything that you and I have gone over?
No, sir.
Okay. Is it still your intent to enter a plea of guilty in this case?
Yes, sir.
All right. Then I'm going to ask you, as to count 1, possession of marijuana with intent to distribute, a severity level 3 drug felony, how do you plead? Guilty or not guilty?
Guilty.
All right. Mr. Johnson, I'm going to ask Ms. Thibodeau from the prosecutor's office to tell me what she thinks the facts are in this case. I want you to listen closely, because when she's done, I'm going to ask you if that's what happened, okay?
Okay.
Ms. Thibodeau.
On September 7th of 2020, a trooper from the Kansas Highway Patrol was patrolling on I-70 westbound at exit 421A in Kansas City, Wyandotte County, Kansas. The trooper checked the speed of a black 2018 Hyundai Sonata with a Missouri temporary registration. That car was going 86 mile per hour in a 55 mile per hour zone. The trooper did pull that Hyundai over. The car had a odor of marijuana coming from the vehicle. The driver of that vehicle was identified as the defendant, Eddie Joe Johnson Jr. The defendant had 2 warrants out of Wyandotte County. They arrested the defendant and did a search of the vehicle. In the vehicle, they found a clear plastic baggie with a green leafy substance. The trooper believed that leafy substance to be marijuana. He did field test it and it tested positive. There was approximately 50 grams of marijuana. They also found a camouflage Nike fanny pack. Inside that fanny pack, they found a red digital scale, unused clear plastic baggies. They found $841 in United States currency in the defendant's pocket. And due to the officer's training and experience, he believed that the scale in the baggies and the amount of money with the amount of marijuana that the defendant was intending to distribute that marijuana.
All right. Mr. Johnson, did you hear what the prosecutor had to say?
Yes, sir.
Is that what happened in this case?
Yes, sir. That's what went down.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered into this plea. He knows the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and I will in fact find that the defendant is guilty of count 1, possession of marijuana with intent to distribute, a severity level 3 non-person drug felony. Per the plea agreement, the other charges are dismissed. I'm going to order a pre-sentence investigation. I would like to set the sentencing also by Zoom on December 18th at 10 o'clock. Mr. Matthews, would that date work for you?
Your Honor, I can do that day. Thank you.
All right, that's when I'm going to set it. Would you like to be heard on bond, Mr. Matthews?
Yes, I would, Your Honor.
All right.
Your Honor, I would ask the court to release him on an OR bond. As the court had pointed out, the plea agreement in this case is for probation. He's currently on probation. I've talked to him and he's indicated to me that if released, he will immediately report to probation. And because he's already got that monitoring set in place, Judge, I don't think he's a flight risk and I think he can be monitored. And I would ask the court to release him on an OR bond.
Ms. Thibodeau.
Judge, the state would not object to that as long as the court reminds the defendant that if he fails to appear for his sentencing or commits a new crime, the state isn't bound by our plea agreement.
Right. Okay. So basically what they're telling me, Mr. Johnson, is, you know, the state's agreeing to probation, but if for some reason you weren't to comply and show up at your next court date, they're going to be released from that requirement and they could argue against probation due to your failure to show up. Okay. So you need to make sure you're going to be living with your mama here.
Yes, sir.
Okay. All right. Well, good deal. I know your mom and I know that she'll make sure you do what you need to do. All right.
Yes, sir.
I'm going to release you on OR today. I don't know how they go about. I know that Andrews County has to bring you back to Wyandotte County for you to be released. I don't know if they'll get to that today. I hope so, but I'm going to get the order right over there so they can get it as soon as possible. Okay.
Okay.
We don't have a PSI request. Dave, can you get one together and get it over to probation so that so that they can contact them and set up a PSI?
Yes, Judge, I can do that today. And I'm also being reminded by Ashley from probation that the orders would need to be on both cases.
The releases?
For the OR, because
Right,
if they're
yes.
not on one, he might still be held on the probation.
Right. I will make sure that I get both case numbers on there so he gets released.
Thank you, Judge.
All right. So our sentencing is December 18th at 10 a.m. Other things for our record today.
Not from the defendant.
We
Nothing.
are adjourned. All right. Mr. Johnson, good luck. I'm gonna get that release over to the jail right now so they can start working on it. I don't know if they'll get it done today or not, but probably tomorrow at the latest. Okay. When you report to your probation officer, let them know that we didn't have a PSI request. And if they need that kind of information to do your PSI, they'll be able to get it from you there, okay?
Okay,
All right, good luck, Mr. Johnson. We'll see you in December.
okay, thank you.
Thank you, Ms. Donna.